Yes.
The concern of the petitioner's counsel, Malad, I beg to mention item number 17, Malad. The hearing matter, Malad, 2021, Malad, origin recorded call for. I have received the record yesterday only, Malad. And it's sometime to Malad.
Who is appearing for the other side?
Uh,
Mr. K.K. Parashar, Leonard CGC, with consent from the other side, submits that he has received the records called for only yesterday and accordingly seeks a short accommodation to go through the same and assist the court. Prayer is allowed, relist on such and such date.
27.
Map, your lord. Map,
Yes, you settle that. Yes.
map, your lordship, my lord. Lordship, with the consent of the other side, I beg to mention item number 13 of the release, lordship. This matter has been substantially heard by coordinate bench of this honorable court, lordship, earlier.
Mr. Roy,
Lordship. Record
in item 13, Mr.
N.K. Sharma, lordship.
N.K. Sharma and Mr. S.S. Roy, learned CGC, for the petitioner respondent respectively, jointly submit that the instant matter has been heard at length by a coordinate bench. Let registry verify and list accordingly.
Deeply obliged, lordship.
May I please, my lord? My lord, I beg to mention item number 5. Please adjourn the matter for today. As-
Why?
As the counsel is not well, he is admitted to ICU.
Your name?
J. Mosang.
Have you informed? You are for the petitioner?
Yes,
As prayed for by MSJ,
Mosang.
Sir Learned Counsel appearing for the petitioner on the ground that the conducting counsel, Mr.
I.S. Mazumdar.
I.S. Majumdar is admitted, is admitted in the hospital for medical treatment, relist on such and such date. Give after 3 weeks. Yes.
May your lordship, listing of a read petition, your lordship. On Friday, obligate.
Friday is a holiday. You want to come?
No, lordship.
You
On-
can come. I can list it.
Lordship, sorry.
Huh?
On
The trend
Wednesday.
is also being developed to work on holidays. If you are willing, I am willing.
On Wednesday, your lordship.
All right.
Oblige, your lordship.
Yes.
Wait, please, the lordship. Lordship, I beg to mention item number 12, lordship. Let this matter be adjourned for today.
I think you have already circulated an advance adjournment slip,
Yes,
right? Your name?
Lordship N. Ali.
N. Ali.
Yes.
Mr. N. Ali, Learned Counsel, appearing for the petitioner with consent from the other side and by circulating advance adjournment slip seeks for adjourning the matter for how many days?
2 weeks.
For 2 weeks. Prayer is allowed. Relist on such and such date.
Obliged, lordship.
Yes, please call the list.
For Uddal, supplementary, item number 19.
Mr. Mohanta, you'll have to wait for one more matter. Yes, who is there? Nigel? Ako ang pisat malito.
For admission, item number 1.
Yes, Mr. Mohanta. Some rejoinder was supposed to be filed here.
No, I was directed to have the inspection.
Hmm?
On the last, by the last program, I was directed to have inspection.
9-12 order lordship basis. 9-12. Government has already been obtained. Sitting out with new pay commission. How much is the loan? It is very big. Very evasive. Very evasive reply. Instructions rather of the government. So it shows.
What does your instruction say, Mr. Gogoi?
As far as the issue is concerned, my lord, regarding, my lord, enhancement of the pay of the petitioners, my lord, that, my lord, it will be placed before the next pay commission. So that's my instruction. In fact, that was the stand in the affidavit of it.
Then what is to be done?
My lord, I will pray, my lord, after the election, my lord, probably the assembly elections, it will be notified.
The
Let's say after
prayer,
every 10 years, my
Mr.
lord,
Mohanto, what are you praying in this writ petition for? Upgradation?
Yes, enhancement, my lord.
My pay should be enhanced because similarly situated police officers, even constables have been paid higher. Less
See, Mr.
qualification,
Mohanto, right now, they are not denying it also.
but they are not exceeding also.
Correct, but then if you want the matter to be heard today, it's in the admission, I'll fix it for hearing and I'll hear it. But you have already heard what Mr. Gogoi have said.
Yes.
They are
No,
not
they have
denying
been-
it right now. They are saying that they will place it before the new pay commission,
Yeah.
which
Not-
is going to be constituted very shortly.
Shortly.
If you want, I can accommodate you by adjourning this matter for 3-4 weeks and see how it develops.
Lord,
So the choice is yours.
my lordship will appreciate. Pay commission will come when nobody knows. And how much time pay commission will require, that's also
All
known.
right, then this is come for admission today.
Yes,
Very well, I'm admitting and I'm fixing it for hearing.
yes,
Readings are complete.
Yes, sir.
yes, yes.
You don't, Mr. Mohanta, you are not going to find any reply or you've already filed it?
We have already filed.
Okay. Heard Mr. K.K. Mohanta, Learned Senior Counsel, assisted by Mr. K.M. Mohanta, Learned Counsel for the petitioner. Also heard Mr. B. Gogoi, Learned Additional AG, appearing for the state. In pursuant to the order dated 9/12/2025 passed by this court, Mr. Gogoi, on instruction, have handed over a copy of the communication dated 17/1/2026,
22 meter.
a copy of which has been placed before this court, which indicates that the state government is in the process of constituting a new pay commission, and the finance department is of the view that the petitioners may place their demand before the new pay commission, which will be constituted very shortly. It appears a copy of the communication dated 17/1/2026 is placed on record and marked as X. Upon hearing the learned counsels appearing for the parties and having perused the materials available on record, it appears that the petitioner has a prima facie case. The matter requires a full-fledged hearing. Admit no formal notice as parties are represented. List for hearing in the month of
February, my lord.
March 2026.
Lordship
Give a
may
date. Yes.
Fix a date,
17th month.
17th. Or 7th.
Item number 2.
Online.
Yes, Mr. Das.
Well, in this case, what is happened, my lord, petitioner before this honorable court is was a grade 4 employee, my lord.
Hmm.
Only because of some dispute regarding my lord date of birth.
This is a part heard mat or
Yes,
no?
my lord.
No, it
Initially
says this,
hard, it's
yes, but
several, on
then,
several occasions it was hard.
yes, the order says this matter will not be treated as part.
Yes, my lord.
Okay.
Thereafter, my lord, what is happened, my lord, one inquiry report was annexed by them, my lord, in affidavit in opposition regarding the issue of the date of birth, my lord. Because, my lord, at the time of initial date of my initial date of birth was, my lord, 56. They have recorded, and somehow it was there, my lord. But subsequently, date of birth was in the year 1966, and it was also accepted by the department. And so far, my voter ID, my lord, PAN, Aadhaar card, or everything, 1966. Subsequently, I have challenged, my lord, the writ petition, another case, my lord. That is also before, it is not listed before this honorable court today, my lord, 638425. So both the matter possibly maybe take up, my lord.
The other matter is admitted,
Yes, my lord, it was notice issued, my lord,
not admitted till now.
not admitted, my lord.
But this matter can be otherwise admitted, Mr. Nayak.
Yes, my lord.
I think.
Heard Mr. Das, Learned Counsel, H. Das, Learned Counsel appearing for the petitioner. Also heard Mr. P. Nayak, Learned Additional AG, Assam, and Mr. R. Boro, Learned Standing Counsel, Accountant General, A&E. The matter requires full-fledged hearing. Admit no formal notice as respondents are represented. A relist along with
WPC number 6384/25, my lord.
on such and such date.
Short date 64.
Item number 6.
Kiman dice ta?
10 months.
Little bit earlier, my lord, because he required.
Next. Yes, instruction, Mr. Chutia.
My lord, I am told by the colleague, my lord, Bodhishattva Patel, she received something, my lord. So, matter may be taken up next week, my lord. He will play.
Heard Mr. A.Y. Chaudhary, learned counsel appearing for the petitioner. Also heard Mr. T.C. Chutia, learned additional senior government advocate. Mr. Sutia's learned counsel, learned additional senior government counsel submits that the instructions as called for has been received by his colleague MSM so-and-so, learned additional senior government advocate, and the same will be placed on the next date of hearing. Prayer, in view of the aforesaid endorsement, relist on such and such date. You want your name?
Yes.
You're for whom? GU. Your name? So and so for GU. Respondent GU.
Obviously. Much over.
29 January. Item number 4.
Yes.
Lordship, kindly pass over the matter for the time being. My senior is on another court.
Yes, but it's a termination matter. Matter will require to be admitted. Why to unnecessarily keep it pending? Who's
Not
appearing for the other side?
For the time.
Where is Ms. Sharma? And CGC?
Your Lordship, my
All right, since the respondents are also not there. I've kept it for some time. You want it to be passed over for the time being,
yes,
right?
yes,
Orders, item number 6.
May it pleases your lordship, on behalf of B. Kaushik, your lordship, I am praying for adjournment, your lordship, because his health is not well, your lordship. Kindly grant us more.
What happened to him?
He is falling sick, your lordship, high fever, your lordship.
Okay.
And yesterday also, your lordship is not happy.
As prayed for by MS?
Pidas.
Pidas, Learned Counsel appearing for the contemner.
Yes, sir.
On the ground that the conducting counsel, Mr. B. Kaushik, is unwell, relist on such and such date.
I'm deeply obliged.
On 3rd February.
Deeply obliged.
Item number 8.
Yes, Mr. Chaudhary.
The petitioner was placed under suspension.
Yes, Mr. Anthony.
Madam, may kindly be passed over for the time being.
Time being. Next time you want to make a prayer for time being, in case a senior counsel is appearing on the other hand, then you please inform them, because he's been waiting here since 10:30.
I will do the lead, madam.
You know, he may have other matters to attend as well.
Yes, ma'am.
Pass over.
I'll wait for some.
So you inform whenever Mr. Nath is ready.
Okay.
Item number 9.
No, please, your lordship. Official indicated that the service of respondent number 4 is complete. My lordship, if some official note is there.
Respondent number 4 is complete.
Yes, my
lordship,
lordship,
we have filed our-
return back, my
You
lordship.
are for 4.
Yes, lordship.
Or you are appearing for 4.
Yes, lordship.
Okay.
And we have filed our vakalatnama.
Okay. Heard MS? Huh?
R. Begum.
R. Begum, Learned Counsel appearing for the petitioner, also heard MS? S. Patwari, who enters appearance on behalf of respondent number 4. Where is CKS Barua? None appears for respondent numbers 1, 2, and 3, despite the name is also not shown. Stop, huh? It further appears that the name of Mr. CKS Barua, Learned Government Advocate Assam, but this is Government Advocate. None appears for the respondent numbers 1, 2, and 3 Thula. In view of the appearance of Miss MS so-and-so on behalf of respondent number 4, service in respect of all the respondents stands complete. Yes, when do you want?
4 weeks maybe.
MS so-and-so further seeks 4 weeks time to file return in the matter. Prayer is allowed. Relist after 4 weeks on a date to be fixed by the registry.
Obliged.
On 5th March. Supplementary is item number 20.
Please, your lordship.
Yes, what is this IA?
Lordship, this IA is filed for recalling the order dated 18/12/2025.
Who is appearing for, if you are filing for, on behalf of the state,
Lordship, Agriculture Department.
your agricultural department.
Lordship, by
So, then notice has to go.
Lordship, kindly, because
No, but how can I pass an order without hearing the other side?
Lordship, kindly pass over the timing. I will.
You want me to recall the order?
Lordship, imposing the cost part only. Lordship, I have already filed.
Who is
affidavit.
appearing for the other side?
A. Chakraborty, Lordship.
Have him here.
Lordship, I'll. kindly
Okay. I'll give you the time. You bring him.
Lordship.
It will pass over time being worried about. When she, you inform, huh?
Lordship.
Yes.
Court hearing item number 10.
Yes, Mr. Pathak.
My lord, this is against an order of termination and challenge to the disciplinary proceedings. Otherwise, the legal issue is on a very narrow compass, Your Lordship. The inquiry report was never furnished to the petitioner. And without furnishing the inquiry report, penalty was imposed. Now, the prejudice which is prima facie caused, Your Lordship, is there were 3 charges framed. And in the inquiry report, the report categorically held that only 1 out of the 3 charges are confirmed against the petitioner. Now, the inquiry report of the disciplinary authority proceeded on a assumption that all the charges have been found to be proved against the petitioner. And because the inquiry report was not furnished, I could have at least made a representation saying at least only one of the charges has been found to be proved. So some lesser penalty could have been imposed. Now,
Dismissal from service.
dismissal from service. So if I may take your lordship to the show cause.
Yes, yes.
Like, I will have to go through the records only, Malad,
Have
because
it.
record is not with me, Malad.
What records? Affidavits have been filed.
Affidavit, Malad, I have taken the second copy of your lordships.
I'll have a look at it.
I have the.
Because let's start, otherwise I will have nothing.
Yeah.
We have, it's already not even 11 o'clock. Most of the matters are already over. Yes.
Lordship will find the show cause notice at page number 25.
Hey, second copy to DD sir. DD sir. Oh, thanks. Page
25. It begins at 25. The charges your lordship will find at page number 28.
25 it starts,
It
isn't
starts.
it? 14/12/2009.
14-12,000.
What was the post that you were holding?
I was
SDO?
SDO. I was in the treasury branch, a treasury officer.
Senior assistant in the TN branch.
Treasury nobis branch.
TN means
Treasury nobis.
treasury.
Nobis.
How do you spell that?
It's
Okay, anyway, you give
NA
me that later.
yes, your lordship.
Yes. You
Okay.
read para 1.
Very well.
Let us understand what is it.
You are hereby required to show cause under Rule 9 of the Assam
Let's
Services.
read para 1.
Very
That while you
That while you were working as senior assistant in the Treasury Nobis branch of the SDO Civil Vishwanath Chariali, during the period from 91-92 to 9507, you were responsible for examining the treasury challan submitted by the Mozadars of Vishwanath subdivision for depositing the land revenue under the head of accounts so and so into the State Bank of India Vishwanath Chariali through the Sub-Treasury Office Vishwanath Chariali. Your duty was examining the treasury challans, and if it was found correct, you are to initial the same and put up to the branch officer for his signature and hand over the same to the Mozadars concerned. After that, it is the duty of the Mozadars to get the treasury challan passed by the treasury officer Vishwanath Sub-Treasury for depositing the amount into State Bank of India Vishwanath Chariali and submitted copy of the deposited treasury challan to SDO Civil Vishwanath Chariali. Moreover, Moza commission bill which is due to the Mozadars should be adjusted with the excess cash in hand retained by the Mozadars. This should be done under book transfer system. But instead of that, you have received the following cash amounts from the Mozadars irregularly and illegally without any authority, detail of which is furnished below. You have also prepared the treasury challan yourself as shown in the following table.
On verification?
On verification, it is found that the Moza Commission bill drawn from your end in the name of Mozadar, which was allotted by the government from time to time. Moza Commission, which was received by the Mozadar at the time of collection of land revenue and deposit it after deduction of their commission. Amounts drawn in the name of the Moza Commission bills. Not a single challan was seen in the hands of the Mozadar, and also in received schedule under the head of account so and so with effect from 1994. TV numbers and their drawal date as shown below, which are seems to be misappropriation of commission bill. TV appears to be treasury voucher, your lordship. Number 4. On verification, it is found that the same amount as shown above for rupees 3,88,742 deposited in the State Bank of India, Vishwanath Sariali, through the Vishwanath Sub-Treasury, duly numbered and authorized by the Vishwanath Sub-Treasury, have not been entered in the government credit scroll for the concerned bank as a result of the said amount having not been deposited through treasury. Challan have not credited to the state exchequer. This is a prima facie case of criminal conspiracy and misappropriation of government revenue.
Allegations are very serious.
Allegations are serious, punishable under the relevant provisions of the Indian Penal Code and the Assam So-and-so Act. But it is seen that you were senior assistant of so-and-so branch, office of the SDO Civil Vishwanath Sariali. You have unofficially received rupees so-and-so in 129 numbers of challan during the period of so-and-so to so-and-so from the Mozadars, Bagmora, Behali and Sakhmato respectively at different times during the said period, preparing the treasury challan yourself in 129 number of challan, passed it by yourself and got it passed by the Treasury Office Vishwanath Sariali and also State Bank of India Vishwanath Sariali with the help of one Shri so-and-so senior assistant of SBI officer Vishwanath Sariali involved in this scandal. But it is found that the said amount has not been entered in the government credit scroll of the State Bank of India, and as a consequence, the said amount of rupees 3,88,742 has not been credited to the state exchequer and thus misappropriated by you through fraudulent means. The subdivisional officer Civil Vishwanath directed the Mozadars of Vishwanath subdivision to deposit all the amounts collected by them as tax of Mahuma Parishad, for which revenue deposited under heads of account so and so. Accordingly, you received the said amount of rupees 2,17,455, but you did not deposit the same. It is specifically mentioned by the ADC in charge Vishwanath subdivision to the Deputy Commissioner Sonitpur by letter number so and so dated 7 July 2007 that the Mozadars of Behali, Bagmora, Sakhmato and Vishwanath had submitted petitions stating that they had deposited the amount collected by them as tax of Mahuma Parishad for revenue deposit under the heads of account so and so in cash to Shri Pradeep Saikia, that is the petitioner, the dealing assistant of TN branch of SDO's office, and they were requesting for challans.
This may not be that relevant, no?
Yes, the charges are on the next page.
Yes.
Therefore, it begins at the top of the page, page
Where?
number 28.
Yes.
You are charged with misappropriation of government money through fraudulent means amounting to a sum of rupees 3,88,742. That is preparing 129 numbers of treasury challan by yourself, passed it by yourself on behalf of the BOTN branch. You did not deposit the cash in the State Bank of India Vishwanath Sariali through treasury during the period of February 2006 to March 2007, details of which is shown above. In the treasury challan, no initial stroke signature of the SDO Civil Vishwanath and branch of.
In short, the charges are that you have not, your duty was to examine the challan and then initial it,
Yes.
if it's correct, right?
Yes.
And that you have not done it properly, rather you have misappropriated, you have collected, you have not deposited.
Yes.
These are the, in short,
Yes.
these are the charges?
And the second charge is that when the Mozadars deposit their revenue, they deduct their commission from the revenue itself. So that was the procedure which was apparently being followed.
Okay.
But here what the allegation is that instead of writing it off as a deduction, he has withdrawn another amount for that payment to the Mozadars.
Okay.
So these are the three charges, Your Lordship. So the misappropriation of an amount of 3,88,742, of an amount of rupees 60,58,952,
And
Of
2
an-
lakh
2 lakhs.
17,000.
17,455.
This you have not deposited.
This, yes.
This is what you have collected from
We
the
have
Mozadars.
collected, we have shown to be collected but not deposited.
All right.
Our reply, Your Lordship, is at page number 31.
Page number?
So it starts at page number 31.
Yes.
Lordship has to.
Yes.
The relevant portion, Your Lordship, will find at page number 32. I'll just read the second paragraph onwards, Your Lordship.
Yes.
That, sir, since April 2005 till March 2007, I not only verified and passed 129 challans of Mozadars of Sakmuta, Behali, and Bagmari Moza, but much before that, since when late Prem Prasad Acharji was transferred, I verified and passed all treasury challans of all Mozadars of all Mozas. In the above circumstances, the allegations that I prepared and passed the 129 treasury chalan of Sakmuta, Behali, and Bagmara Moza since April 2005 to March 2007 is not true.
So these are explanations that you have
Explanation.
given. right?
Yes, Your Lordship.
Because I don't think I need to go into all this because I'm not sitting in appeal.
Just
Isn't it?
one portion, Your Lordship, you find
Yes.
on the procedural aspect, page
Yes,
number
yes.
36.
36.
36. The last paragraph at the bottom of the page.
Yes.
It may be relevant to state that in spite of the direction issued by Your Honor by letter dated 22/1/2010 under number so and so to examine the documents in connection with the allegation brought against me, the said documents could not be shown completely. The head assistant informed me that these documents have been forwarded to the Deputy Commissioner. I have submitted my reply to the show cause issued by Your Honor on the basis of the documents received for examination without any delay. And I have gone through the affidavit. This has not been denied by the state.
What is this?
Some documents were supposed to be, I requested for some documents.
That was not given.
That was not given. Now, inquiry officer was appointed, presenting officer was appointed. Lordship will find the inquiry report at page number 45.
Page number?
It starts at page number 45. The date of the report is 6th April 2010.
Yes.
Inquiry report against Shri so-and-so, senior assistant under suspension, office of the so-and-so, so-and-so. Lordship will come to the relevant portion at page number 46. Substantiation of allegations. May I read you?
Yes.
From the nature of the allegations, it is evident that this was a white-collar crime that was committed over a period of time right under the nose of the administration but went unnoticed because of the willful concealment of facts by the perpetrator of the act, the lackadaisical attitude of the officers in not tracking and ensuring proper deposit of government money into relevant heads of account by a system of follow-ups and test checking, and 3, insufficient knowledge of officers and staff about prevalent government rules and practices that enable the perpetrator of the crime to subvert the system with impunity and almost go away scot-free. Now, coming to the core issue, whether the allegations could be substantiated or not, conclusive evidence point out that the allegations are without any trace of doubt true and could prima facie be substantiated. A perusal of the bank statement and the statement of the then Treasury Officer, Shri So-and-so, indicates that the government money, as mentioned in the statement of allegations, has not been deposited in the appropriate head of accounts, whereafter it has been credited through the SBI so-and-so to the government account at RBI. In the case of Moza collection amounting to rupees 3,88,742 and that of rupees 60,58,952, the amount being the commission bill of the Mozadars, it is seen that these amounts have not been received by the bank and hence not credited to the government exchequer.
This
This reveals
that at some level,
not this reveals that at some level.
I was apprehending you're going to hammer on this sentence. Huh?
And then he later on goes on to clarify, Your Lordship. This reveals that at some level, the government money has been misappropriated. The same may also be said of the government money amounting to rupees so and so, being the amount in cash collected from the Mozadars as tax of the Makhuma Parishad. Thus, without any iota of doubt, it could be concluded that the above allegations of misappropriation of government money is a substantive and undeniable fact. Culpability of Shri so-and-so.
You are Pradeep
I am
Saikia.
Pradeep Saikia. For long 17 years, Shri so-and-so has served as Tozi Novis. It is
So
natural.
this is Tozi Navis. NAVIS.
NAVIS, Tozi Novis.
Yes.
It is natural to.
So what does it mean, Tozi Navis?
I think he is the person to whom the Mozadars collect the revenue and deposit it. Perhaps it's a.
Mr. Chutia, you may throw some light on what Tozi Navis means.
I do not have much of an idea about the system, but it appears that he is the person to whom the
Perhaps.
revenue was deposited.
Anyway, in case you have it, you can let me know. Otherwise, I was just curious to know what does, because the nature of job has come out in the show cause. So that I think we are clear.
So from the affidavit, I have gone half of the pages, I have seen the documents were provided to him and every possibility was given to cross-examine, but he denied it. That was
See,
my.
that is all right, but one of the main ground which Mr. Pathak in the beginning has already argued was that the inquiry report was not submitted.
That is his alias Balat.
Correct. And he says that out of the 3 charges, admittedly only 1 has been proved. However, the disciplinary authorities, according to him, assume that all the 3 charges have been proved and accordingly dismissed him from service. So he is saying that had the inquiry report been charged, he would have had an opportunity to pursue. You see, anyway, this is what Mr. Pathak have submitted. He's yet to substantiate his arguments by taking me through the pages.
Appeal is not disposed of, appeal is pending. As per affidavit, my lord, he submitted an appeal before the authority against the dismissal order. That has been pending as per my affidavit. I don't know, my lord, Pathak will know
No,
whether
that-
appeal has been disposed of or not.
That appeal, your lordship, was time barred.
Time barred. Anyway,
Because
let us see.
Very-
Hmm.
If I may read your lordship.
Yes.
For long,
Yeah,
seven-
you may take your seat. You may take your seat.
for
Yeah.
long 17 years, Sri so-and-so has served as Tozi Nobis. It is natural to assume that he is thoroughly acquainted with all aspects of land revenue matters, especially those relating to the Mosdari system. A perusal of his recorded statement reveals that he claimed that he was not conversant with the system of book transfer, which is the prevalent practice as far as the commission amount of the Mozadars is concerned. This could not be accepted. As the Tozi Nobis, Sri so-and-so is the custodian of all records and documents relating to Moza affairs. He is also responsible, accountable, and liable for deposits and commissions relating to land revenue under the Mosdari system. Therefore, he could not claim exemption from his onerous duties as Tozi Nobis. In the extant case, a perusal of all the records and statements of all the officers, staff, and Mozadas revealed that Sri so-and-so, out of mala fide intention to misappropriate government money, misled his superior officers throughout the years by not resorting to the usual practice of book transfer and instead putting up the commission bills for cash withdrawal. This violates the norm of proper financial practice as there is no likelihood of immediate cash disbursement to the Mozadas who had already retained their commission from the Moza collections. This also could have been accepted had he deposited the cash amounts in the State Bank of
So
India.
this indicates that the inquiry officer has given reasons.
Yes,
There are reason findings, and I don't think you can argue
yes, just
against
last
them.
paragraph
Yes.
on page number 48.
Yes.
The misappropriated amount went undetected all these years because of the willful concealment by the very perpetrator of the act. Therefore, the matter of rupees 60 lakh so-and-so, the culpability of Shri Pradeep Sakya could be established beyond reasonable doubt. However, in the case of the other 2 amounts, rupees so-and-so and so-and-so, the role of Shri so-and-so is suspect as also having misappropriated said amount.
All right. So charge 1 is proved.
2 of them are not true.
2 is not proved.
Yes.
Okay.
Now, this report was never furnished to me. In fact, I got it for the first time along with my penalty.
Is this an admitted fact, Mr. Chutia?
In the affidavit, they have remained silent.
Is this an admitted fact that this report was not given?
That is, my lord, I have not got it, my lord.
Huh?
I have not found here, my lord, in the affidavit.
There is nothing to show that it has been given.
Yes, given.
So that means it is not given, because why I'm asking you that, if that is so, then instead of going ahead with so much in the depth of the matter, this matter can be sent back to that
Yes.
to that part, because I am not interfering
Yes,
with
yes,
the
yes.
inquiry proceedings.
My lord,
The allegations are serious, Mr. Pathak.
I-
I'm sorry.
I agree.
And it appears that you have participated, procedures have been followed, and substantial procedures, Mr. Pathak, have been followed. And there are reasons. It's a reasoned order.
he is only allegation is
If I may just show your lordship what has happened, the prejudice, the inquiry report, just one sentence.
Hmm.
The second paragraph of the inquiry report at page number 49, the prejudice which has been caused to me.
Yes.
After careful examination of the above report, it is found that all charges against.
That's right. So
Yes.
I am with you on this.
That
I'm
is my
with
limited
you.
submission at this stage.
I'm with you on this.
Yes.
criminal case is pending before the
Let it be. So, Mr. Chutia,
remand back to the my lord, authority.
yes,
And providing him an inquiry report.
and
After
to
submit-
start from that stage.
Then started,
Okay.
but no reinstatement, my lord.
Huh?
No, this
No-
order has to be
no
set
order
aside,
of
your
the-
lordship.
No, while during inquiry, you were under
I was
suspension.
under suspension.
So it will go back to whatever stage it is.
Because his order
He
has
cannot
said
be, you cannot expect him to be dismissed after I interfere
Now
with
I've
the
already
order.
retired, you know.
Retired, my lord.
Anyway, that whatever that will follow, it will follow.
Followed by.
You have already got your suspension allowance and everything.
I do not have that instruction.
Heard Mr. K.P. Pathak, learned counsel, appearing for the petitioner. Also heard Mr. T.C. Chutia, learned additional senior government advocate, appearing for the respondents. You're appearing as the additional senior government advocate. So and so, huh? For all the respondents. By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned order dated 16/2/2012 issued by the Deputy Commissioner Sonipur.
So, Deputy,
Sonitpur or
Deputy
Sonipur?
Commissioner Sonitpur, you know.
Sonitpur,
Sonitpur.
whereby the service of the petitioner was dismissed upon drawing an inquiry against him by show cause notice dated 14/12/2009 issued by the respondent number 3 and the impugned inquiry report out of the said proceedings. Stop. The brief facts of the case is that the petitioner, while was discharging his duties as a senior assistant in the office of the SDO Civil Vishwanath Charili, senior assistant of the Tozi Navi's branch, in the office of SDO Civil Vishwanath Charili, Ashoka's notice was issued by the SDO Civil Vishwanath Charili on 7/5/2007, alleging inter alia that some cash receipts, challans, were not properly recorded by him in accordance with the present procedure. The 3 charges that were drawn against the petitioner reads as under 1, 2, 3, page 28. Along, while furnishing the show cause notice and the charge sheet, list of documents and list of witnesses were also, along with statement of allegations, were also furnished to the petitioner. Thereafter, the petitioner, by letter dated 27/2/2010, furnished his show cause reply. His reply to the said show cause notice, wherein he denied all the allegations. Thereafter, an inquiry was held against the petitioner, wherein the petitioner was given all opportunities, and upon completion of the inquiry, the charge number 1 was found to be proved, while the other 2 charges were found not to have been proved. By inquiry, thereafter, an inquiry report was submitted on, what is the date of the inquiry report?
The report is 26/9/2010.
On 26/9/2010. Pursuant to the said inquiry, pursuant to the submission of the inquiry report, the Deputy Commissioner Sonitpur Tejpur, by order dated 16/2/2012, was of the opinion that since all the charges leveled against the petitioner were found to have been established. Where is that punishment part?
That your lordship will find, the offense is thus very serious, the third paragraph on page number 49.
Yes.
The offense is thus very serious.
And upon being of the opinion that the offense being very serious, the petitioner was dismissed from his service with effect from the date of issue of the said order. Situated thus, the present writ petition has been filed. Mr. K.P. Pathak, learned counsel appearing for the petitioner, submits that the disciplinary authorities have, without furnishing a copy of the inquiry report, has dismissed the petitioner from service. He further submits that a bare perusal of the dismissal order indicates that the disciplinary authorities were of the opinion that all the charges leveled against the petitioner were found to have been proved, while on the face of the inquiry report it is apparent that only charge number 1 was proved before the inquiry officer.
It is actually charge number 2.
Charge number 2? Okay. Make it charge number 2, huh? Tar agoto koislo. So that was charge 2 which was
Charge
proved?
2 was found.
Okay, okay.
1 and 3.
Okay, okay. Monot thoba, huh? Per contra, Mr. T.C. Chutia, learned counsel appearing on behalf of the state, fairly submits that there is nothing on record to show that the inquiry report has been furnished to the petitioner prior to issuing of the dismissal order dated 16/2/2012. Stop. Having heard the learned counsels appearing for the parties and having perused the materials available on record, it appears that the punishment of dismissal from service has been issued to the petitioner without issuing a copy of the inquiry report. The requirement of issuing the inquiry report prior to issuance of the punishment is to give an opportunity to the delinquent to represent against the inquiry proceedings held so as to put his defense as why the inquiry proceedings ought not to be accepted by the delinquent officer. That it is apparent that during inquiry only the charge number 2 has been proved, while both the other charges, charge number 1 and charge number 3 were not proved. However, the disciplinary authority in the impugned dismissal order dated 16/2/2012 inadvertently was of the opinion that all charges against the petitioner were found to be established, which appears to be absolutely incorrect on the face of the record. It is apparent that because of non-furnishing of the inquiry report, serious prejudice has been caused to the petitioner. That being so, the impugned dismissal order dated 16/2/2012 cannot stand in the scrutiny of the eye of law. Accordingly, the impugned dismissal order dated 16/2/2012 stands quashed and set aside. It is needless to be clarified that the disciplinary authorities are at liberty to furnish a copy of the inquiry report to the petitioner if so advised and restart the proceedings from that stage. Yes. Anything more? I don't think anything is required. Allowed. Writ petition allowed.
Deeply overlooked.
Yes, next.
Timing item number 4.
Yes, Mr. Roy Chaudhary.
Gopal, my lord, sorry, I was
No, it's all right. Yes.
with your lordship. My
This
lord,
is for admission, Mr. Roy Chaudhary.
Yes, my lord.
Yes, where is your counterparts?
I was informed also earlier in the morning.
They were not there. What is to be done? Pleadings are complete.
Kidding, sir.
All right, then I'll admit it.
My lord, then it will go for, because I am terminated while giving appointment, my lord, the domicile certificate is not required in the state of Assam. I was working as a constable in CISF.
Who is appearing with the other side?
My lord,
Why don't you have them? I can hear it then. Or otherwise, I'm having
I
it
think-
fixed on Thursday. You
Thursday-
inform them.
Thursday is, my lord,
Thursday or next Tuesday?
next Tuesday will be better.
All right. Heard Mr. P.K. Roy Chaudhary, Learned Senior Counsel, assisted Learned Counsel appearing for the petitioner. Also, none appears for the respondent on call. Relist on such and such date.
Oblige.
You inform them.
My lord, my lord.
The office of Mr. Roy Chaudhary, in the meantime, shall inform the learned counsel appearing for the respondents as regards posting of the matter on the next date.
Oblige me.
Timing item number 8.
Yes, Mr. Sharma.
My lord, contempt, my lord. On the last occasion, my senior.
Yes, Mr. Anthony.
Senior has not yet come. Senior is not yet come.
He's not yet come.
So he's in port number
Then let's have the contemner only appear personally, Mr. Anthony. You are agreeing to that also. Yes, Mr. Sharma, what is the contempt?
My lord, since the matter pertains to an update on his reinstatement, my lord, the order was
Matter pertains to?
an update, my lord, on the last order, my lord, pertaining to an order 7/1/2026, my lord.
It says on the next date of listing, Mr. Nath shall place before this court the compliance order.
Understand, one of the facts are that he was supposed to be reinstated pursuant to the order which was passed in the month of May in 2024.
Mr. Anthony,
Yes, ma'am.
I understand you have newly joined,
Yes, ma'am.
right?
Yes.
When did you join?
Last in the month of November.
Very well. So now next time, when your senior ask you to appear in a matter, you also independently apply your mind.
Definitely.
What is expected from you is to go through the last order, right?
Yes, ma'am.
These are available in your phone. If you don't have the order in the file, it will be available in the phone.
Yes, ma'am.
You look into it. Now, when you see the last order and you see that there is something that your senior has to now inform the court or place something before the court,
We have received,
try to get that
we
information.
have received an instruction, my lord.
What is that instruction?
My lord, I have a copy.
Yes. The reinstatement is in the process.
Yes, my lord. My lord, on the last occasion, my senior friend did not have clarity on the stage of reinstatement because what had happened, my lord, there was an appeal which was also preferred.
This is the last order. This is the order, a communication of 19-1.
Yesterday, my lord.
So,
Yesterday, my lord.
according to this also, it says, after careful consideration, the competent authority has issued directions and the department is presently in the process of issuing a formal notification.
Ideally, my lord, the division bench of this honorable court had already settled the matter, my lord, by dismissing.
So, I think it will be done. Let
Yes.
me have this on
Yes,
record
yes,
and I'll give another 2 weeks time. Let us see.
Or my lord,
It is expected that, yes, what is your or?
my lord, since the matter will not take lot of lordship's time, maybe a short date just for an update, my lord, on the instructions. That's all, my lord.
That's what I'm saying.
Yes, my lord.
I think it will not, I don't think anything is going to come that before 2 weeks. Anyway, you give me a date. Heard Mr. M. Sharma, Learned Counsel, appearing for the petitioner. Also heard Mr.
G. Anthony.
G, na?
G. Anthony.
Mr. G. Anthony, Learned Counsel, appearing on behalf of Mr. D. Nath, Learned Counsel, appearing for the contemners. Pursuant to the order dated 7/1/2026, Mr. Anthony places a communication dated 19/1/2026 received from the Office of the Secretary to the Government of Assam Personal Aid Department, whereby it is informed that after due consideration of the matter, the competent authority has issued directions and the department is presently in the process of issuing a formal notification of reinstatement of the petitioner in service, which shall be issued shortly. Keeping in mind the aforesaid instruction, this court, without entering into the merits of the contempt petition, redirects posting of the contempt proceedings on such and such date. It is needless to be expected that by the next date of listing, all the necessary formalities are completed and the order of the court is complied. So give a date. Mr. Anthony, you can place this document, and why were you hesitating? Why were you seeking time? Huh? What is not authorized? You have it in front of you. You are wearing a gown. You are authorized. Yes, next.
I'm grateful, man. 1st February. Timing item number 19.
Mr. Anthony, I'm taking this on record. You need a photocopy, take it from the office. Huh? A copy of the said communication is kept on record and marked as A. Etu mark kore dibo. And give a photocopy to Mr. Sharma also.
Yes, my lord.
Yes.
May I please your lordship? Lordship, I have been instructed to withdraw the writ petition by the petitioner.
Withdraw.
Yes.
Are you sure?
Yes, sir.
You receive instructions.
Yes.
Item 19. Your name?
Begum Shajida.
Anybody from PNRD, government, AG, heard MS? Your name?
Begum Shajida. B. Shajida.
Pala? Heard MS so and so. Also heard, yes, Mr. A. Chakrabarti, Learned Government Council for the state respondents, and Mr. R. Boro, Learned Standing Council, PNRD. Learned Standing Council AG. And PNRD, anyone there? Mr. Chalia, where are your friends from PNRD? Give a name. Cakewar. You're informed, huh? MS so-and-so, Learned Counsel for the petitioner, submits that she has received instructions from the petitioner not to press the instant writ petition and accordingly seeks withdrawal of the same. Prayer is allowed. The writ petition is stand dismissed on being withdrawn.
Yes, sir.
No interim, na? Any interim order there? Hello, Baha. Yes. All right.
Typing item number 20.
Yes. That is that
That-
recall. Yes.
Part of
I cannot have any substance to make.
What is that you want to recall? Let's see which is the order.
lordship. Lordship, kindly, I page number 12, lordship.
Yes. Yes.
Lordship, I want to explain the circumstances why this order was placed, lordship. Initially, this matter was handled by Mr. Bikram Chaudhary, Standing Council, Agriculture Department. Later on, it was handled by me, lordship. And accordingly, I have emailed to the department seeking instructions so that I can file an affidavit on their behalf. The department has sent instruction to Mr. Chaudhary on 6/1/2025, lordship, but they have not replied to me. So I was in a impression that
It has not
it
come.
has not come, and on that day, lordship, 18th,
All
12th,
right. Sufficiently explained. Okay.
lordship, I'm extremely sorry for inconvenience because we could not.
No, that's all
because
right.
of this
It's
conversation,
not
lordship.
about the inconvenience to the court. It's about the inconvenience that is caused to the party. You see, non-filing of a counter for 2 years
I'm a-
delays the
Lordship.
proceeding, right? A litigant is suffering. That
Extremely
is
sorry for
the whole thing, you see. Anyway, since you have given the explanation which appears to be bona fide, I am waiving the costs. Okay.
highly obliged.
Your name?
Z Bora Lordship.
Heard MSG Bora, Learned Counsel, appearing for the applicant. Also heard Mr. A. Chakraborty, Learned Counsel, appearing for the respondent stroke writ petitioner. Stroke writ petitioner. By way of this application, interlocutory application, comma, the applicant is seeking recall of the order dated 18/12/2025 passed in WPC 5781 of 2023, whereby a cost of rupees 5,000 was imposed on the respondent Agriculture Department for non-filing of the counter affidavit for more than 2 years. Stop. MS so and so Learned Counsel for the applicant submits that earlier that initially the matter was handled by another standing counsel, and inadvertently after she has been appointed as an standing counsel of the Agriculture Department to represent the instant case, the instructions were sent to the earlier set of counsel, for which she was unable to file the counter affidavit, and accordingly seeks waiver of the cost imposed on the Agricultural Department. Mr. So-and-so, Learned Counsel for the writ petitioner, does not oppose to the prayer made in the I. Having heard the learned counsels appearing for the parties and having perused the materials available on record, it appears that due to reasons beyond the control of the standing counsel MSG Bora, Agricultural Department, the counter affidavit could not be filed, for which ultimately a cost have been imposed by this court. It further appears that due to the change of counsel,
He's still in the panel, Lordship.
but you have been instructed to appear in this matter.
Lordship.
Okay, হেতু change করে দিম, but as far as this matter, you have been in now, isn't it?
Lordship.
Due to the change of due to the change of counsel for appearing in the instant matter, the instructions having been sent to the earlier counsel, which was David, this court deems finds the aforesaid explanation bona fide and sufficient, and accordingly, in the interest of justice, allows the prayer made in the interlocutory application. The cost of so and so stands waived. The rest of the order remains the same. I stands allowed.
Highly obliged.
Item number 11.
Lordship, here in this matter, a view of the PPG department has been sought for. A view from the PPG department has been sought for, Lordship.
It's still not there.
Not there, Lordship.
All right. As prayed for by Mr. D. Upamanyu, Learned Standing Counsel, Health Department, relist after 2 weeks ago on such and such date to enable the Health Department to place the what view? To place the required documents for preparation of pensionary benefits to the appropriate authority.
Lordship, to place the view from the Administrative Reforms, Training, Pension and Public Grievance Department, Lordship.
Wala, you have to
Write it down.
write it and give it to
Yeah,
him. Yes.
highly obliged.
Just give it right now, huh, Upamanyu?
Yes, Lord.
Yeah.
Right. 17. Obliged.
Item 14.
Yes, Ms. Barua?
Yes, your lordship. This is a matter for removal from service. The petitioner was alleged for some unwanted substances for which he was not even given an opportunity, and straight away he was been removed from the service. That is what we challenged before this court. The annex, your lordship.
The
will find order-
removal from service is under challenge.
Yes. yes.
Removal from service.
Now, there are certain glitches to that. I will shed some light. So your lordship may just see page number 19. This is the first order. That on the basis of some of preliminary.
Respondent
inquiry-
is CGC.
Yes.
Coming lots from.
Yes.
So on the basis of the first preliminary inquiry, he was not been given a chance and he was straight away been removed.
Page.
That page 19. So that is what I challenged. I was only arguing that matter, and that came in my favor. And after that, I was ordered for reinstatement. Then your lordship will also find that they started again the proceedings, DP proceedings, for which I was been granted a sanction leave of 10 days. And after I went back to home, so I met with an accident, and then I cannot appear before the DP inquiry committee. And for which I was again been removed from the service by stating as an ex parte.
Ms. Barwa, I'm sorry, I could not follow the entire link. Submit slowly. Yes, initially you had approached this court for what?
For challenge of removal of service order.
Okay, and that was allowed.
That was allowed.
You were reinstated.
Reinstated.
And which?
And I was again-
Listen to the court. Why are you in such a hurry? Where do I find that operating portion of the order? Which page?
That is at page 30. Para 17.
Page 30.
Page 30, para 17.
Yes, please place page para
res-
17.
If I may read.
Yes.
The respondents are directed to reinstate the petitioner within a period of 4 weeks from the date of receipt of certified copy of the order. The respondent may thereafter proceed against him in accordance with the law, if so advised, after giving the petitioner an opportunity to
So
show cause.
basically for show
Yes.
cause was not given initially.
Yes.
So
yes.
therefore it has been remanded.
It was remanded.
Now show cause has been given.
Now, after what happened, your lordship will find what has happened. They again started the DP proceeding, but in the meanwhile, they also
DP?
allowed disciplinary proceedings.
DP.
DP. So in the meanwhile, they again given me a sanction leave of 10 days. So then I went back to my home, which is at UP, and I met an accident there. And simultaneously, I cannot appear in this fresh DP. So what they did is they removed me again by stating as an ex parte order, by giving us an ex parte order.
No, but you have been issued show cause notice on 19/9/2023. Against this, did you give reply?
23, if your lordship may
Page
just.
32. What is the show
I'll never
cause notice?
satisfy. Your lordship may just.
Where is the other side?
21/12.
What is this?
Bring some records, sir. You bring
But
some
the
record.
court cannot, because she has to reply to the petitioner, otherwise it will be an empty formality. Court proceedings cannot go on like this.
Your lordship may find page
Wait,
47.
your counterpart is not here.
She was in fact there. She kept some file and she again went.
So then you wait for some time. Yes, call the next matter.
Here you go.
Yes, Mr. Sharma.
Yes, Madam. This matter relates to the instant petition, it is third litigation matter
For pension
arising out of
benefits,
the third WBC case. And for-
third time you have come.
This is the first WBC case, my lord, I had to prefer, because I am the sub-engineer grade 2, I was. But I had been deprived from my legitimate right to receive my arrear salary with effect from March 2008.
Huh?
With effect from March 2008,
till the date of filing the first WPC case in 2016. That was about 9 years. Now, their only point is that I was unauthorized leave. I had taken unauthorized leave, but I had only for 1 year, my lord, I had taken leave on medical grounds. Because due to their negligence on their part, I had lost the vision of my right eye. 5 times operation had been taken place. Right eye, I complete vision. I have lost the vision of the right eye. Secondly, my lord, I was suffering very seriously chronic asthmatic trouble and suffering for it. And that's why I had to take leave for a very limited period of 1 year. That is also admitted by them, for which they had, but just as preliminary, I had to take submit. I'll submit before this honorable court. Then 14/8/2009, for the first time, they had issued a so-called notice with a statement of allegation that I was unauthorized absent for this period.
2000?
For March 2008 to 2009, my lord.
Yes.
Only for a limited period. And but
Yes.
I had duly submitted my leave applications on medical ground.
All right.
And these were already considered by this honorable court in the first WBC case. Then, my lord, but after issuing so-called notice, I had submitted several representations, but they remained silent. They did not do anything regarding the first so-called notice.
All right.
Then, my lord, in 2013, I had drawn the attention of the honorable governor because I am heavily financially constrained not to approach before this honorable court, that my missus had approached the governor by submitting a representation. The governor directed this deputy secretary to interfere with the matter. The 2 letters I will come your lieutenant. On perusal of the letters, what was the negligence on the part of the respondent authority, your lordship will find.
What is the prayer here?
Yeah, I have annexed here with my lordship, kindly answer me. Page 183, my lord.
Huge petition.
Yes, my lord.
Huh?
That's initially regarding negligence.
What negligence?
Yes, ma'am. Page number
Ultimately, what
183.
is the prayer?
Now my prayer, my lord, this is the
What
third
is
reading.
inflicting upon the petitioner by sanctioning very nominal amount of area salaries?
Now, lordship, after what happened, the first WPC case was heard by this honorable court after hearing both the parties. Honorable court was pleased to pass judgment on
Mr. Sharma, can we go one by one? I have not yet understood what is exactly that you are asking in this writ petition. So can you please, can you kindly
I'll place
inform the
one
court
by one by
that,
one.
what is the prayer in the present writ petition?
Present writ petition, my lord, there are 3 issues. First issue, to set aside the expertise inquiry report.
Okay.
Secondly, my lord, to release all the arrears salaries with effect from March 2008 till 31st December 2017 under ROP rules 2016 and 2017.
March 2008 to?
March 2008 to 2017.
Yes.
Apart from that, my lord, they had also not released another amount from February 2008 to March 2008.
What is this
About
amount?
4 lakhs rupees. We have calculated, my lord, very properly.
No, this is also area salary?
Area salary. They had not paid me under ROP rules, my lord.
Okay.
They had paid me under old scale, subject to the deduction of that old.
Okay.
Now this was our area salary. This is the second
Now,
issue.
what is that?
Third issue, my lord. During the pendency of the second WBC case, I had challenged the expert inquiry report in this second WBC case. Because they have, whenever they have violated the first WBC case, I have filed contempt case. During the contempt case, after about 1 year, they have suddenly issued the expert inquiry report. After 1 year, that within the outer limit of 3 months, they should have completed the inquiry. Outer only 3 months was given to them.
Yes.
And from the first so-called notice, 14/8/2009, no second so-called notice. And the relevant documents, about 10 documents, they are directed to furnish me so that I can file my written statement within 10 days. Then I had, in compliance with the said judgment, I had approached them by submitting my representations. that you give me the 10 numbers of documents to verify. 2 months time they have taken to furnish my documents.
All right.
Because my lord, what happened? The judgment has been passed 12/6/2000.
Where is that first judgment page?
Page number 1995.
Huh?
Page number 90 to 95.
90.
99, 90. Kindly, the relevant person, your lordship, will kindly see. Uh, 90. 94, my lord. Paragraph 7, my lord. 94, paragraph 7.
Yes.
Yes, my lord. I have considered the submissions advanced by the learned counsel for the parties. I have also perused the materials available on record, granting the prayer of the read petitioner in the given circumstance would amount to allowing the read petition without there being any conclusion in the departmental proceedings initiated by the department, as may be noticed herein above. The various documents referred to by the read petitioner and the documents relied upon by the respondents would require meticulous examination, which in my considered opinion can only be exercised in a proper departmental inquiry. In that view of the matter, instead of dwelling upon the various documents prescribed before this court, the read petition is disposed of with the following directions. This page number 95, my lord. There are 4 points. Number 1 point, my lord, the respondent government will proceed with the inquiry proceedings from the stage of the so-called notice that is 14/8/2009. That was the only notice, so-called notice was issued, they could not complete it. Issued to the read petitioner, and the read petitioner shall submit his reply to the same afresh in terms of the notice within 10 days, and the petitioner shall also be permitted to examine and inspect all documents proposed to be relied upon in the inquiry proceedings. That was the first point, my lord. Second point, my lord, the petitioner shall join his post immediately, and the respondent authorities shall examine the admitted dues pending against his salary. He shall be entitled to his salary otherwise from the date of his joining to his post. Considering the fact that the petitioner is due to superannuate in the month of December 2017, the departmental...
So this permitted the respondents to proceed with the inquiry afresh from the issue of from the stage of issuing show cause notice.
Yes.
Okay, then.
Then, my lord, number 3, my lord.
That's all right. Then what happened?
Number 3 point, my lord.
It says the department shall conduct the inquiry proceeding
within the outer limit of 3 months.
Read it, yes.
Yes, my lord. Number 4, the inquiry proceedings shall commence immediately.
Right, you need nothing substantial is there in that part of the order. Main thing is to proceed, right?
Yes, my lord.
Now what happened there?
Whatever, my lord. And another point I want to draw the attention, because my lord, after 2009, after availing my leave application on medical ground, I had duly joined in my service, but I was not allowed to put attend the register from the very beginning.
So here also it was given that it is also hereby provided the petitioner will be allowed to put his signature in attendance register, and he in turn shall give full cooperation in the inquiry proceedings.
Yes,
so that was still not allowed.
I then after
you filed a contempt.
Passing this judgment for the some attendance register they had allowed, but I was attending my office from 2009 till the date of retirement. My service was utilized by them. I have all the documents, relevant documents I have annexed here regarding it. Now, my lord, what happened? Within the outer limit of 3 months, they could not complete the inquiry. Just before my retirement and after expiry of the 3 months, in the meantime, I had submitted a written statement, my lord, immediately after receiving document. Then they had remained silent after, in the contempt case, my lord, after various orders. In 2018, an expert inquiry report was issued without the date on which it was prepared.
All right.
When they had it prepared. I'm coming, Annexer, my lord, Annexer 3, impugn expert inquiry 100 to 110.
Page?
Page 100 to 110.
Yes.
My lord, this is an expert inquiry report along with a letter Annexure 4, my lord. This letter forwarded by the respondent number 2 to the petitioner.
Compliance report.
Yes, my lord. Regarding the expert inquiry report to submit my reply.
Yes.
But there is no date mentioned when the inquiry report was prepared. Behind my back, it was prepared. It is a clear violation of Assam Disciplinary Service Rules 1964. In compliance with the judgment, I should be given an
You are challenging the inquiry now
Yes, my lord.
in this proceeding.
Now, my lord, what happened? Now, that is the second position. This the expert inquiry report.
Yes.
Now, they had ultimately, from various orders from the contempt court, in order to get relief from the contempt proceeding, for the first time, right, Annexure 48, page 292, they had released a very nominal amount of 292. 292.
Yes.
This is an abstract, my lord. They had calculated 7,29,697. But how they have calculated this amount? They have remained silent. Thus, some dates are given here, and total amount the out of 7,29,000. It is a matter of interest, my lord. 51,000 was illegally deducted by them. Why they have deducted 51?
All these case laws you are relying.
No. My lord said,
Who submitted all these case laws?
oh yes, my lord.
You are relying.
I have submitted. Only last occasion I have submitted. Certain cases for honors, convenience, if it is.
But then why, have you filed any written arguments?
Yes,
You filed.
I have a file.
Where is your written argument?
Oh, written argument I have not filed.
Then why don't you put all the points in a summary sheet and give it? Because it looks, it's a voluminous petition. You are relying on so many case laws. And I've heard you for some time, but I'm yet to understand what is exactly that you are asking for. I think it would be better if you put it in a point-wise summary, because there's an old case and there is no written argument or summary written.
My lord, only I had submitted case laws. On page only 1 or 2 case laws orders. It is quite similar to poverty case.
But I don't know. This is what is before the court. You have handed over.
That's
So,
now, regarding the matter is not very simple. Now what happened? During the pendency of the first WBC,
what is it, Mr. Bhattakur?
they have not released the entire amount.
1 second, Mr. Sharma.
May I see page 96 of the petition. Earlier round of litigation, my learned senior had already pointed out. Then, alleging non-compliance, this was filed, my lord, this contempt petition.
Yes.
Now, my lord, this order makes it clear, my lord, what part was complied with and what remains to be complied with.
Page.
It starts from page 96. Then, my lord may come to page 97.
Yes.
Last paragraph of 97.
Yes.
A reading of the directions issued by the said order makes it discernible that first, there is a requirement of bringing an early end to the inquiry proceeding as per so-called notice dated 14/8/2009, and to allow the petitioner to immediately join his post and thereafter to pay his admitted dues in respect of his salary. Next paragraph, madam. In respect of the requirement to bring the inquiry proceeding to its end, it is stated that the inquiry proceeding resulted in a requirement of the respondent authorities to pay the petitioner an amount of 7,29,697. Out of that, for some reason, 51,452 was deducted. It is stated that the said amount is in respect of pending salaries that were due to the petitioner. It is stated that out of the said amount, an amount of 6,78,000 had already been paid to the petitioner except for the amount of so and so. Now this amount has been paid, my lord. So this issue has come to an end. That inquiry report found that this amount needs to be paid to him. Otherwise, no punishment was imposed. So this amount has already been. So this issue is, my lord, now it is being hit by estoppel, my lord. No appeal was made by the petitioner. So this issue of inquiry proceeding, my lord, cannot be raised again.
How? But this is a contempt proceeding.
But contempt proceeding, my lord, observation is clear, my lord, that
Maybe, but
Yes.
this was not challenged. The inquiry was not under challenge. The inquiry report was not under challenge before the contempt proceeding. The contempt court may have made observations saying that it has been complied. But that comply, I don't know, Mr. Bhattacharya, at this stage, prima facie, I don't think that issue has been settled by the contempt court. Because you see, the contempt court does not have a jurisdiction of adjudication.
Yes.
Contempt court is only for punishing,
But-
isn't it?
Yes. But the contempt is observing whether the earlier round of litigation.
I mean, unless you show me something, you see, because this observation is also it is only saying that this has been done. Whether it has been validly done, not validly done, this is not the observation. It is only narrating what has been done. It's a fact that after the inquiry, it was found that 51,452 was deducted, correct? And that is the observation, and this was asked to be paid. Had already been paid to the petitioner except the amount of 51,452. And then there was a direction, you pay this, right? So this has been paid,
No.
not paid till now.
Then again, I have, for violation of
This
the
amount
contempt
is
case, I have second contempt case is filed. It is pending now.
No,
Okay.
51,452 is paid or not paid?
Not paid. 51,000 is not paid. This area salary. This is according
Mr.
to
Sharma is saying it is not paid, Mr. Bhattacharya.
not paid.
And a second contempt, he says, is pending.
Second contempt case is pending. And moreover, my lord, here my learned friend has, however, the petitioner raises an issue that the amount he is entitled would be more than rupees.
Correct. So this is not
Yes, that is
settled.
Your lordship has rightly
The
pointed out.
only thing, my lord, that is not settled, if there might be some deduction, my lord. The court has only observed that what remains.
You
to-
see, I think this matter will definitely need an elaborate hearing. To facilitate the hearing, I am asking the learned counsel
Yes.
to submit written arguments.
Written argument.
Written argument. And if Mr. Bhattacharya, you find out what has happened to 51,452, there is a direction of the court. A contempt court has given direction that you pay. Accordingly, we are of the view that the requirement of the order so and so has been complied. And no, before that it says we direct that the balance amount of so and so be paid to the petitioner immediately. The contempt court has given this direction. Why this has not been paid till now?
No, as per our.
Because if I find that this has not been paid, I can ask the person, the hearing officer, to be personally present before the court. So Mr. Sharma, I will ask that contempt case also to be tagged along. Let it all come together.
Yes, my lord, I will appreciate, I have appreciated. My lord, one point is just left. My learned friend has pointed out, in contempt case disorder, my lord, 51,000 was to be released along with provisional pension for the first time. After disorder, after 9 years, they have released as per disorder. But suddenly they have stopped the provisional pension.
You find out
Now,
what has
provisional
happened.
pension, that may be continued till the
See, that I cannot give you any order like that. There is no application to that effect. I'm hearing the matter, Mr. Sharma.
Yes,
You save your energy for the next date. We'll go one by one. Because there is no application to that part. Is that prayer before this court today for releasing that provisional pension?
No, yeah, at least my lord, whenever after passing this order, they started paying provisional pension.
I've understood, but
Yes.
now they have stopped.
They
This is
stopped.
this is the allegation that you are giving. But where is that on paper? Is there an application?
Yes, my lord, in affidavit in reply, I had mentioned.
So there is no application, right? So if you want to file an IA, you file with this with a specific prayer.
Provisional pension.
Correct. You make it in IA. And give me a date which is convenient for you.
My lord, I want to draw the attention of this honorable group. During the pendency of the second WBC case, a fresh cause of action arose by issuing 2 letters by them, AGOPs. What happened? They are going to fix the provisional pension, 18,000 so and so, as a regular monthly pension. And that's why I had prayed before this honorable court to set aside these 2 letters also, because in the event of allowing
Heard Mr. S. Sharma, Learned Senior Counsel, assisted by B. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. I. Thakur, Learned Counsel, appearing for respondent numbers
For PHE department.
for Standing Counsel PHE. Mr. C. Barua, Learned 6 and 7 AG. Nobody, anybody else? For effective adjudication, for effective hearing of the writ petitioner, the parties are requested to submit written arguments in the matter. It appears that a contempt case being contempt case number being so and so is pending before this court. Let registry list this matter along list the said contempt proceeding along with this matter on such and such date. Give a date. In the meantime, the writ petitioner is at liberty to file. No, hit
Contempt is second contempt is
give the date.
494, madam. Second contempt. 494. Madam, date maybe fees second week of.
All right, you ask your junior. The date will be given as per your wish. And what is the contempt number?
494/23.
490?
Of
4 of
23.
2023.
It's a long pending matter, madam. They have-
Give a date. Yes, you file your written arguments. Yes.
That being accepted.
Not of us.
Yes, Ms. Sharma. Yes, Ms. Barwa, now you can continue.
Yes. Now, your lordship may just see page 32. This is the first show cause. Dated 19/9/2023. If your lordship has found.
Yes.
So this is the first show cause. And then a charge sheet was given, which is at page 39.
This is the first show cause.
First show cause.
Yes.
After the High Court order, this is the first show cause.
Yes.
And then page 39 is the charge sheet.
Yes.
So this is the memorandum of charge sheet, which was given to the petitioner. And thereafter, surprisingly at page 47,
Yes.
a memorandum of charge sheet under major penalty so-and-so of RPF rule by memorandum so-and-so dated 15/12/2023 along with the statement of article of charge issued to the petitioner is hereby withdrawn. This one again been withdrawn. And after that, your lordship will find page 112 in the affidavit in opposition.
100?
112.
Yes.
If your lordship has found, this is a letter dated 26/12/2023.
Yes.
Your lordship will see para number 3 and 4.
Yes.
Permitted to avail 10 days permission leave to avail from 27/12/2023. This was the leave was granted to me. Thereafter, I went to my home where I met with an accident. And all the medicals we have submitted here along with this main petition.
Where is your reply to the show cause notice?
The first show cause notice, this was completely withdrawn, and the second show
Yes,
cause
I'm
notice,
asking this only. 19/9/2023,
The-
the show cause notice which was given after the High Court's order. Where is your reply?
we
You have not given.
because this was completely been withdrawn. Then again, they gave us a second show cause notice, to which my reply is at page 78.
Page?
78.
I'm not, I'm a little confused with your dates right now. After the High
After the
Court
High Court
has
order-
given a direction for
Yes.
fresh
Yes.
proceed, right?
So they have initiated the disciplinary proceedings.
Again.
Again.
So they had given a show cause
Show
notice.
cause notice.
Which is that show cause notice? At page 32?
Yes, page 32.
Correct?
Yes.
Now against this show cause notice, where is your reply?
We have not given any
That
reply.
is exactly I'm
We
being
have not given
asking.
any
So
reply.
you are saying that you could not reply because after seeking leave, permitted leave, when you had proceeded, you got into an accident, and because of all that. And
This-
now,
you-
now they, because they had no information, they have obviously proceeded with the inquiry, right, Ms. Sharma?
No, your lordship, there is a catch. The 19/9/2023 was the first show cause which was given to me. Thereafter, they are about to give us a memorandum, the charges,
Hmm.
on the basis of which I was required to file my defense statement. So this was given to me on 15/12/2023.
Yes,
After that,
yes.
they withdraw. They withdrawn the charge sheet by allowing me a 10 days sanction leave. This leave letter is here in
Yes.
the reply.
Yes,
So this is the chronology of events.
yes. After that,
After that, I went back to my home where I met with an accident, and thereafter, they asked me to join, and which I couldn't due to the seriousness of the accident.
what about page 48? Charge sheet?
This this is the second charge sheet,
Yes.
and on the basis of which,
After the withdrawn,
yes, your lordship may just see page 78.
yes,
This is the submission of interim defense representation against the finding of DAAR and inquiry.
yes.
We have given this.
This is you.
Yes.
You have replied.
Yes.
You have replied to this.
Yes.
Have you said that you were unwell or where?
That are completely there.
In
If
page
your lordship,
78, 79, where have you said?
your lordship may just see.
Because I
That I-
understand, Ms. Barwa, what you're trying to say is that behind your back an inquiry has been done,
Done.
and you were precluded to participate in the inquiry because you met with an accident when you had proceeded on leave.
Yes.
This is what is your
Yes,
case,
yes.
right?
This is
However, they went ahead
Went
behind your back.
went ahead.
Now, if you have to make out a case on that, then you have to show before this court that you had duly informed them
Yes.
that you were not well, that the medical reports which you are now showing me from the writ petition, you have to show that these were given to the other side
Yes, your lordship
and that they
may-
have not considered all
Yes,
this.
your lordship
You
may
please
just
show
see
me that
Page 69.
page.
69.
Yes, this is in Hindi.
Yes.
I cannot read
No,
Hindi.
there is a type copy of page
give me-
69C. 69D is the Hindi copy.
Acha.
69C.
Yes.
That my humble request is that I am a constable so and so. I was granted leave from this and this by Mr. Assistant Security Commissioner during vacation. I had gone to Ghaziabad for my personal work, and due to heavy fog, my motorcycle collided with the divider. The local people took me to the nearest district hospital. I had a severe back injury due to which I was having difficulty in standing and walking. The doctor did the X-ray report of my waist, which revealed a problem in my waist, and after that, sir, again went to the doctor for checkup from 29/1/2024, in which the doctor after checkup gave me an additional bed rest of 1 month. After that, I went to the doctor for checkup on 29/2/2024, in which the doctor gave me additional rest of 15 days, due to which I am unable to come, sir. A copy of the district hospital slip and copy of the X-ray is printed before you with folded hands. I request, sir, to please grant me or give me permission to extend my leave. It will
Yes,
be a great
yes.
mercy. So this was given to them, and this has already been reflected in the inquiry report also, that I have duly informed them. But thereafter, they didn't consider no ML applicant. Even I am ready. Till date, I am ready to face the inquiry. But the only thing is, at least a reasonable opportunity.
So the
has to be
matter can be
given.
remanded back to that
Yes,
stage?
Yes.
If
And
this
if
court
not-
finds that you have been deprived to
Yes.
participate in the inquiry.
Now, if your lordship may also just see the RPF rules.
Yuck.
वो मोटा कहता है ऐसे
আমাৰ লগত নাই নেকি কিতাপখন চাই লওক।
That 153.
This is Railway Protection Force rules.
Yes, Act and rules together.
What were you saying are RPF rules?
RPF.
You see, by these short things,
Yes.
these people will not know. It's not a very commonly used. Yeah. I was also thinking, what is this act that you are referring to? Railway Protection Force Act. Yes.
So now here in this
Section
153.9 rule.
Rule
Rule
1.
153.9.
Yes.
It says if the enrolled member charged fails to turn up on the day fixed for the start of inquiry.
159?
153.9.
Okay, okay.
It says if the enrolled member of charge fails to turn up on the day fixed for the start of inquiry and no reasonable excuse is offered for not being present on the fixed time and day, the inquiry officer may commence the inquiry ex parte. But already I have the reason. The valid reason was given to them. Now, if your lordship may also just see in that same rule, 105.2.
Yes.
Now the default part. 105.2 says, leave shall not be granted to a member of the force whose conduct is under inquiry except when it is required for hospitalization purposes or in extreme emergent case. So they gave me a 10-day leave. And then after I gave a reasonable excuse, they didn't consider it and they went into proceeding ahead ex parte against me.
Yes.
So therefore, this matter is required to be remanded back.
Anything more?
Yes.
Yes. Yes, Ms. Sharma. First thing first, were you aware that
Lordship,
the delinquent had met an accident, that the delinquent had given a
10 days leave, Lordship, but the letter, the representation or whatever is 69C is showing it's of 1/3/2024. Till date, the proceeding is over because the order is of 2/3/2024. So, although she is saying that she had intimated, that is of 1/3/24 and our order of removal is of 2/3/2024.
Can I have the dates, Ms. Sharma?
Yes, Lordship.
You give me one by one,
Yes, Lordship.
all the important dates. Because if we have to enforce, पानी को पहले एक बार निकल दो तो बेटा पानी दे हाँ हम ब्लैक पैसा चेंज कर लो बस because in case we need to enforce 153.9 then only in the event if an excuse was shown on the date of the inquiry, on the date that is fixed, if a reason is given, in that situation, you cannot go ex parte. You may have to consider that. That is all, isn't it? I think 153.9 shows that. This is why I was asking, when did you inform? I wanted to know that. So you give me all those dates because you may have given, in fact, it shows the fairness of you to allow the person to go on leave pending inquiry. Correct? The power is already shown 105.2 during hospitalization or in extreme emergent cases. Here the reason was given.
Page 68, the first letter which is 68.
68.
Annexure 8. Yes, page 68. My leave was till 5/1/2024.
So it is about a medical problem.
Yes.
So therefore you gave it. No, there is no difficulty. Now, Ms. Sharma, you have to show What happened? When was the inquiry?
Lordship,
Give me those dates from that High Court's order.
Lordship.
After the High Court
Yes.
had sent it back, those dates. I want those dates.
The judgment and order of Honorable Court is of 11/8/2023.
11/8.
2023.
Ms. Barua, you may take your seat.
Yes.
11/8/2003 is the judgment.
23.
All right.
Then we reinstated him on service on 14/9/23.
14/9/23
23.
reinstatement.
Yes, Lordship.
Yes. Then
Then on 19/9/2023, inquiry report was provided to the petitioner for submitting his representation against property.
no, but then that.
First show cause.
So this is the show cause notice. Okay. Show cause notice. The inquiry was already held completed before that, isn't it?
Prior to that, there was only a preliminary inquiry.
Ms. Sharma,
Lordship.
I think you said inquiry was given. This is 19/9 is what? Please have a look. The show cause notice. By then the charges have not been given.
Lordships.
Though no inquiry was held.
It's only on the.
Show cause notice.
Yes.
Correct.
Lordship.
Then
Lordship, he refused to receive and asking for a Hindi version of the application dated so. Then we submitted him Hindi version of the
when did he ask for a Hindi version?
Hide his application dated 29/9/2023. 29/9/23.
Yes. Then when did you give the Hindi version?
Given him Hindi version along with the document 16/11/23 and he acknowledged it on 18/11/23.
Yes. Then
On 29/11/23, office received his reply dated 27/11/23.
yes.
We perused and we found it not at all satisfactory and not represented properly. So then issued major penalty charges charge sheet under section 153 of RPF rule 87.
Don't say major penalty charges. Then you see, then you keep me getting confused that as if the inquiry is already over.
This is the charge sheet, Lodge.
And you cannot, before starting the inquiry, you cannot say this is going to be major punishment. You
Right.
can't decide the punishment and then go on started doing an inquiry. You are damaging your own case, Ms. Sharma. I'm telling you. Repeatedly, you are giving an impression that the inquiry has already been completed. The order of the High Court was to start it from the show cause notice. Show cause notice, there can be a second show cause notice stage, that is after the inquiry. But here the inquiry itself has happened.
Yes.
So then after on 29/11/2023, after the reply has been given, you have issued the charge sheet. Memorandum of charges, correct?
Lordship.
And then you have, I think, withdrawn it. But before withdrawing it, I think she has submitted a leave.
Yes, on 3/1/2024.
So I want the sequence, date sequence
Logic.
now. After 29/11/23, what happened? The councils, it is very unfortunate because the court is now trying to hear the matter and give a judgment right away in the open court. If you are not facilitating the court with the dates and all, how do you expect the court to author a judgment? This is why I'm asking. I want the dates. Please give me the dates properly.
Lordship.
Otherwise, I'm getting confused now.
Your Lordship will find 26/12/2023, where I was been granted leave.
One second, Ms. Barwa. 29/11/23, you have given a reply. Now that memorandum of charges came when?
Memorandum of charges.
Which was withdrawn. They did not accept your reply.
No.
So what happened then?
And after that was withdrawn and they again.
No. Say one by one. After they did not accept, when they didn't accept your reply, what happened? They issued a memorandum of charges?
Yes, again a second
Correct.
charge sheet was given.
When was that?
21/12/2023.
This was withdrawn.
No. On 21/12, the first was
21?
withdrawn. 12/2023.
No. But when was the first charge sheet issued?
The first charge sheet was issued on 15/12/2020.
This is the date I'm asking.
Yes.
Why is it so difficult
This is
to
the
give?
first memorandum of
Correct.
hardship.
Now, to complete the sequence, I have to get this date, right? Because this is the date which comes immediately after your reply. Why
Yes.
is it taking so much time for you all to give me this date?
I
Now,
have
this was again withdrawn,
withdrawn
right, Ms. Sharma?
Lordship.
When was it withdrawn,
21/12.
Ms. Sharma? 20,
21/12/2023.
21/12,
2023.
23 withdrawn.
Withdrawn.
Now, when did you
And
give
the
that
second-
page 68
Second charge sheet was given on that same day.
on 21/12?
Yes.
21/12/23,
The-
second
yes.
charge sheet.
Second charge, which is
Okay.
at page 51. of
Okay.
our petition.
Now, this page 68, that leave,
Yes,
this is the leave application, right?
yes.
This
3/1,
this was on
three,
three-
3/1,
3/1,
2024.
3/1/24.
24.
Leave application.
Leave application.
And this was granted when?
26/12/2023.
20?
6.
That page you had shown me, no?
112.
26/12.
2023.
How come after? The leave application is 31/1/24 and permission is 26/12/23.
I met with an accident. My leave was till 5/1/2024. I met with an accident and then I gave them one day after I gave them a letter that my leave is required to be extended.
And then they have given.
And then they have denied. They went into ex parte.
No, they've not denied. They've given you permitted to avail 10 days permission leave from 27/12.
27/12. So
Yes,
from
so 10 days
27
have been given.
Yes, only
10
10
days.
days has been given to me.
So then,
And in the meanwhile, I met with an accident. I informed them wide letter 3/1/2024.
where is that?
Page 68 of the petition.
'68. 3/1/24.
24.
Excellent. All right. You see, Ms. Sharma, now I'm again back to square one because I was trying to get this sequence. Now you help me fill up the gaps from the charge sheet. When did the inquiry officer was appointed? What happened thereafter? Because you are saying the inquiry is already over by 2/1/24. And it appears that they have only informed you on 3/1/2024 about the accident. If that be so, then the petitioner will have no case.
Lordship, on 17/2/2024, one Pawan Kumar,
Hmm.
he was nominated as inquiry
On
officer.
17?
He had submitted his inquiry, finding of inquiry to the disciplinary authority on 17.
Ms. Sharma, why are you rushing why are you speeding up the bus? Before the submission of the inquiry, an inquiry officer will be appointed. An inquiry proceeding will be held, correct?
Lordship.
Now, the question that has been posed to you is during that stage, whether you were aware or not that the delinquent was an accident. You are saying you were not aware. So
He
you-
had taken leave for 10 days
Yeah.
and thereafter he has to join on 6/1/24.
Huh.
But he had not joined. We have
Yes.
sent many letters, WhatsApp, etc. to join and come back. I have annexed those callback notices also.
Okay.
Asking him that
To join back.
join back. But
You
he
did not hear. And then when did you appoint an inquiry officer?
appointment date.
You don't have. When did the inquiry proceeding started?
Lordship, the inquiry officer submitted his
Submission will come later.
Lordship.
When did the inquiry proceeding started? It's an inquiry proceeding being under challenge. These dates are not there, Ms. Sharma. You are one of the few lawyers. This court has expectations. Why? Any problem today? You want another date, Ms. Sharma?
Lordship, inquiry proceeding.
By 12 or later. 30% of the nominal.
Have you followed what is happening, Ms. Sharma? Because Ms. Barua is showing us 153.9. Ms. Barua has also shown this court that she was that the delinquent had been permitted to go on leave, right? She has also shown that thereafter the delinquent met with an accident, and then she shows that the delinquent had informed you, the office. Now, if 153.9, it says that if on the date when the inquiry proceeding has been fixed, on that date, if the delinquent does not appear, but suppose the delinquent shows the reasons for his non-appearance, then you will have to accommodate. You can't just proceed ex parte. On the contrary, if on the date fixed, on that particular date when the inquiry proceeding has been fixed, on that date if they don't appear, you are free to go ex parte if there is no reason. That is why I'm repeatedly asking you what has happened. I want these dates. But you are not showing, you are only saying that inquiry was over. But what happened on that date? Where are the inquiry report? Where are the inquiry proceedings? On the date fixed, when was the inquiry fixed? On which date they did not appear? The inquiry officer must have made some notings, no? That the delinquent is absent without steps.
I have to show it in the record.
So where are all that?
That is in the record, Lordship.
So why, but those dates should have been given to the court. The judicial time is being invested in this matter. The matter is posted for hearing. Are you not supposed to go through the record and place it before the court, or are you supposed to go through the record in the court, Ms. Sharma? Please tell the court. Are you supposed to go through the record in the court, Ms. Sharma?
No, Lordship,
Then-
because we have provided it in Hindi, so it translated by Honorable Court on the last occasion. There is a translated version of the record also. which is necessary.
I'm not asking you all that. When a case is fixed before the court and you have the records, are you not supposed to go through the record, Ms. Sharma? Then why are you not
But
giving the
date I
date
have not noted.
on another date? Please go through it. Ms. Barua, I have already heard you. I've already heard you. When do you want, Ms. Sharma?
Any day, Lordship, but I have. to
It's not
prepare-
about Ms. Sharma. I'm asking a very specific question when you want it so that you know how much time you need to prepare. You say any day, and the second, after that, you immediately say you need to prepare. I'm only asking you, think about it when you want it. How much time you need to prepare? I'm giving you that accommodation. When the court is accommodating, then take it.
Yes, February, Lordship.
Heard MSB Barwal, Learned Counsel appearing for the petitioner. Also heard MSB Sharma, Learned CGC. Learned CGC for the state, for the central government. Stop. MSB Barwa has concluded her arguments in the case. During the course of the arguments, MS Barwa, by drawing the attention of the court to Rule 153.9 of the Railway Protection Force Rules 1987, have argued that despite the petitioner having shown reasons for not attending the inquiry on the date fixed, the inquiry officer has concluded the inquiry proceedings in the back of the petitioner, and thereafter the impugned dismissal order have been issued by the delinquent officer. While pointed query as regards the dates on which the inquiry proceedings have been conducted and on which date the petitioner has submitted his grounds for not attending the court have been posed, MSB Sharma, though had the records available with her, however, was not in a position to address the court. In order to accommodate MSB Sharma, relist on such and such dates.
Date?
10 February. Item 16.
May I please, Lordship? Respond number 3, Lordship, I received the instruction, Lordship, that was the title, Lordship. Respondent number 3 had to file a respondent, Lordship. That's why some time will be required.
You want some time?
Want some-
All right. Mr. Patwari,
Yes, my lord.
Okay, as prayed for by Mr.
H. Chakraborty.
So and so learned counsel appearing for the respondent number 3, relist on such and such date to enable the so and so to file reply in the matter which is not opposed by Mr. J. Patwari, learned counsel appearing for the petition.
Here I require some accommodation. Now, the relevant record, General Security Force record is supposed to place for this honorable court. Now, can it be on 29? By then we can place it for the court now.
Mr. Goswami, UK Goswami Leonard CGC seeks a short accommodation in order to produce the relevant records pertaining to the General Security Force Court trial as called earlier by this court by order dated 25/11/2025. The prayer is not opposed by Mr.
And Gogoi.
and Gogoi Leonard Counsel appearing for the petitioner. Prayer allowed, relist on such and such date.
29. Obliged.
Complete.